Asymmetrical Haircuts Justice Update with Janet Anderson and Stephanie van den Berg in partnership with justiceinfo.
Hi, Steph.
Hi, Janet.
So, really, what a pleasure. Here we are, not only in the same city for once, but actually here together at the ICC.
Yeah, we have a lot going on nowadays, and the ICC is absolutely going through the deepest crisis in its history. We now have 5 individuals under sanction by the United States, and everyone in this building seems to be holding their breath to see if the institution as a whole will get sanctioned, and lots of people are ducking behind pillars when they see me rock up.
Yeah, you are exceptionally annoying, Steph. I sympathise with them. I'd also mention people should remember that one of those sanctions, the Prosecutor Karim Khan, is actually also on suspension at the moment, and he's awaiting the results of an investigation into alleged sexual misconduct, which doesn't help the crisis atmosphere.
Yeah, and we had exciting hearings planned for the end of this month with the confirmation of charges hearing for former Philippine President Rodrigo Duterte, but that's now been delayed, and we're going to discuss that in more details in another episode. But meanwhile,
we are here at the ICC because the prosecutor, together with the judges and despite the defence, have agreed to hold a new kind of hearing.
Yes, so the first time ever. So here we got what they were saying about that.
The dock is empty of any potential accused. Joseph Kony is not present here today. Unfortunately, the tentacles of international criminal justice, even though lengthy, with the cooperation of states, whether they be signatory to the Rome Statute or not, have not been sufficient to ensure the swift arrest of fugitives.
And
today we are here on what is undoubtedly a milestone for the court. The first confirmation hearing of a suspect who has never appeared, with the chair at the back of the courtroom sitting empty.
Yep. That was Deputy Prosecutor Mame Mandiai Nyang speaking via an interpreter, and then after him, Lead Defence Counsel Peter Haynes agreeing. It's always rare when you get the prosecutor and defence agreeing, but agreeing that there is a gap in the courtroom. There was a space, there was a lacuna, a missing body, there was a security guard, but there was no accused. So explain to us what's going on, Steph. Lay it out for us about who it is, which charges, and who's been on the run.
So this case is about the leader of the Lord's Resistance Army, a Ugandan rebel group. It is Joseph Kony, or Kony, as we have learned in these hearings. The prosecution wants to charge him with 39 charges of crimes against humanity and war crimes, including mostly charges of conscripting and using children in combat and sexual slavery and forced pregnancy and having forced wives. He's been on the run since 2005, so he's the longest running fugitive at the ICC, and he could not be found. So at some point in 2022, the prosecutor has asked for...
2022?
Yeah, in 2022, they first floated this idea to have a confirmation of charges hearing in absentia, which is rare.
And they were discussing, really, I don't know if we've even mentioned it's northern Uganda. You've mentioned that it's the Lord's Resistance Army, but northern Uganda is about what happened in the period 2002, 2005, about what happened in the internal displaced camps there and at a girls' school. And of course, we had all of that, as I'm sure we'll come to again later. The dynamic Google Earth map took us right there. But we also had a quick chat to somebody before the hearing.
Yes, we spoke to Michael Scharf, who is the former Dean of Case Western Reserve University School of Law and the president of the American branch of the International Law Association, and he explained a bit of the background.
Joseph Kony has been on the lam for 20 years. He's the longest major person with an arrest warrant that has eluded justice for that length of time. And so ultimately they had to do something to show that the arrest warrant was still relevant.
So we have a lot to discuss here, and joining us here in the ICC press room, is this your first time here, Lucy?
It is, yeah. It's the first time I've made it out of the visitor area.
So Lucy Gaynor from the University of Amsterdam, she's been in the courtroom alongside us for the last couple of days. We'll mention that she's written a masterful Substack where she was also musing on gaps and lacunae and what's missing. And we're going to go through some of the bits of the court process together with you, Lucy, and how the ICC are doing on this.
The first impression was that it was very much set up like a normal confirmation of charges hearing. In some ways, the prosecution just introduced the bones of their case and then they went to more details in depth. But it was also different. And here we have Michael Scharf again explaining how it's different.
It's a short proceeding. It's only 3 days long. And I thought that it might have been as long as 6 weeks. They could have made it a mini trial. So it is definitely not a mini trial. Think of it as the highlights of a mini trial in absentia.
Yeah, what he was saying there, Lucy, is that this might have some highlights in it. Were there some highlights for you there?
I think once I got over my initial expectations, there have been highlights for me. I was very critical of doing the hearing, but it's been unsuccessful for me in ways that were different to what I thought. And it has also perhaps been more interesting in ways that were different to what I thought. So I think for me, the highlights really, if you can call them highlights, are really the level of detail that we did end up getting during the trial, but also the completely different kinds of arguments that we got, not just over the details, but over loads of different issues. That was really, really interesting.
Yes, Professor Scharf was actually also, when I was chatting to him, when we were both chatting to him, both Steph and I, he was saying he was hoping for some kind of blockbuster production. And at that point, he'd called it Hollywood style because he really wanted to try and cut through to a wider audience.
People get bored of watching international trials. What they learn about international justice, they usually learn sometimes from documentaries, but mostly from Hollywood-style movies. And so therefore, if you really want to have an impact on the world's population, that's what you want to make this if you're the prosecution. You only have a couple of hours to present your case. So I would wonder if they've spent a lot of time putting together a slick presentation, and they've got plenty that they can use because the Angwan case, they just finished a 3-year trial and they have all the highlights of that trial that they can use. And one of the interesting things about the Angwan case is one of his chief defenses was, it wasn't my fault because Joseph Kony forced me to do these things. Joseph Kony's the bad guy, not me. So he actually spent a lot of his trial implicating Joseph Kony, and all of that testimony and evidence can come in. So not only the evidence of what happened, the consequences, the horrors, but also of Joseph Kony's direct involvement through the eyes of his principal lieutenant. So they have access to all of that, and I'm curious to see how they utilize that in a very short period of time in the courtroom.
So, Steph, how did you find the production values?
Oh my God. Well, it wasn't exactly Hollywood. I don't think it was even Bollywood or Nollywood. I made the joke yesterday that I have a new Fit watch and it measures my stress levels and they're all over the place. And I'm apparently a very high-strung individual. So the stress levels are like at 80 out of 100 when I'm reading a book on the couch. And I was checking them yesterday. I looked at my watch and they were 14 out of 100, which is the level that I sleep. So.
And that was during what?
That was during Niang's presentation of the case before. So,
you're not turned on by process and procedure and a timeline?
Apparently, I mean, I think it is because it was kind of boring, and I wonder how you can make Kony boring. The other, possibly more disturbing conclusion is that I get lulled into a sense of calm by descriptions of atrocities. Our listeners will make of that what they will. But Lucy, Hollywood or no?
Well, not Hollywood, but I'm also never bored in hearings like this. And I also think the prosecutor was a little bit, damned if they did and damned if they didn't, because to have made this very Hollywood would probably have just reinforced so many of the critiques of why you shouldn't do hearings like this without an accused. But then, because it's Kony and because he's been wanted by the ICC for so long, we also then went in with expectations that this would happen. So then people probably did feel a little bit more bored yesterday. But I think just the level of different discussions that have happened in the court, I think there's also been quite a lot of, at times, boredness, but also been quite some tension in the court and quite some emotion. And I think to watch that as an observer, I did not find boring at all.
We should mention we're recording this podcast halfway through the Wednesday, which is, it looks like it's coming towards the end of the hearing, actually being squeezed into 2 days rather than 3, but we don't quite know yet because we're recording it before it's actually over. But I agree with you that there's quite a lot of substance in there. So maybe we should get into some of that because, well, often we have had the ICC's main prosecutor in each case. I mean, Karim Khan is quite larger than life. I mean, he does take up a lot of room. In this case, apart from Nyang, the deputy prosecutor, one of the deputy prosecutors giving his presentation, we heard from quite a number of the office of the prosecutor. Do we know who they all were, Steph?
It's a bit of a source of contention among journalists. What we've noticed is that they don't give all the presentation of all the lawyers for the prosecutor who are in the courtroom anymore, and they will give us the names of those who are speaking, but sometimes not all the names. And we understand that this is maybe a new way of dealing with it, just not to identify everybody. And probably I assume that is because of the threat of sanctions and the kind of increased level of scrutiny and criticism towards the court. But it is a different approach, and it means for us in news agencies that we cannot quote everybody who is speaking if they won't give their full name, because that is just a rule that Reuters, for example, has.
Well, we will be quoting from those that we do have the full names of, and maybe an apology in advance. I don't think we've got any clips from the common legal representative of victims, despite the fact that they had some quite interesting presentation and arguments, because we can only fit so much in to a podcast. So let's kick off. This is Office of the Prosecutor to start with, and we're talking about 39 charges. There's a lot there. They sort of dealt with all of the different material from different angles. So we had the organisational detail from Leonie von Braun.
Mr. Kony and LRA commanders could rely for the obedience in the execution of their orders to commit the charged crimes on a reliable pool of persons, the LRA fighters under their control. Kony used the LRA to subjugate the will of its fighters who executed the crimes. The LRA fighters functioned as tools, and accordingly, Your Honors, their conduct is attributable to Mr. Kony. The evidence shows that he was the uncontested leader of the LRA. Witnesses with knowledge of the internal structure refer to him variously as the overall leader, chairman, president, chief commander.
And then she went on.
And what is it these men wanted to achieve? As demonstrated by the sequence of events charged in this case, the LRA co-perpetrators wanted to attack civilians in northern Uganda, whom they perceived as their enemies, because they believed them to support the government, a government the LRA was at war with. But they also wanted to sustain the LRA, including by abducting thousands of women and children. The charged crimes were all executed through the organized and hierarchical apparatus of power that was the LRA. Control Altar was a governing body and a type of LRA headquarters. It included posts like Army Commander, Deputy Army Commander, Chief of Staff.
From that explanation of the hierarchy and Kony's role, did you find Leonie von Braun's arguments convincing?
I'm not sure about convincing. It wasn't what I expected. I thought it was quite surprising to me how so much of the narrative about the LRA that came from her presentation really didn't seem to emphasize specifics of Kony's role. It was very much about this plan. And I think, there was a lot of confusion I spoke about with some people yesterday over following this document of all of the different leaders of the LRA and where they fit in. And of course, we heard this morning that actually one of them had been portrayed with an incorrect photograph that had not been verified to be them at all. So I think...
And there were a couple of people who had no photographs at all, yet they were all... What often strikes me with these things is it kind of tries to put a number of bits of facts together and make sense of them.
Yeah, and I think it's also potentially a challenge of just narrating the violence in Uganda specifically, right? The LRA is this organization that has been around for so long and we know so much about in so many ways, but at the same time is quite vague and amorphous in so many other ways. And so I think really what we saw in that presentation was the prosecutor trying to really grapple with that tension between how we know so much about certain things and so little about others. And she really tried to bridge that gap.
And then we had, after Leni von Braun, we had Melissa Sims, and she was running through, as far as I can remember, the different types of crimes. And the one that I just wanted to pick out from her was this issue of persecution. That struck me because it's about the idea that under crimes against humanity, persecution, you can say that people of northern Uganda were persecuted for not supporting the LRA, for deliberately not helping these fighters. So here's Melissa's, I think, last remarks.
The prosecution has throughout today highlighted the persecutory behavior of the LRA under the orders of Mr. Kony, and the acts and experiences of the survivors, which I have highlighted today, demonstrates this persecutory intent. Your Honours, the prosecution could only provide a snapshot of the extensive body of evidence coming from its over 180 witnesses. The prosecution submits that there are substantial grounds to believe that Mr. Kony is criminally responsible for the attacks detailed at counts 1 through to 13.
Any comment, Lucy?
I think from a historian's perspective, that was one of the presentations I found the most impressive yesterday because it was simultaneously a chronological overview of the attacks on IDP camps with this legal argument about persecution woven in, which I found actually quite compelling.
And by the end of the first day, we also had a Ugandan member of the Office of the Prosecutor, Sanyu Ndagire, who was really going into detail on the abduction of women and girls and what happened to them in the LRA in quite harrowing detail.
With respect to women and girls that were forcibly integrated into the LRA from at least 1st July 2002 until 31st December 2005 in northern Uganda. Mr. Kony is charged with the following crimes listed in these counts: enslavement, the inhumane act of forced marriage, rape, torture, other inhumane acts of severe abuse and mistreatment, cruel treatment, gender persecution, as well as sexual slavery and forced pregnancy.
Yeah, as you say, Steph, the details were very harrowing. We've got quite a few clips of Sanyu. So here's number 2.
Witness P214, who was herself abducted at the age of 17, states, and I quote, Kony decided to distribute us girls to different commanders as wives. Kony was seated under a tree and called us. He looked at us and told his security guards to pick 4 girls for him to stay in his home. Kony then told the top commanders to also pick girls. The commanders pointed at the girls they wanted, and then their security guards would take the selected girls to their homes. After that, Kony allocated the rest of the girls to lower-ranking commanders. Each commander received 1 girl. The girls did not have a choice but to go with the commanders. we were told on where to go. And if one resisted, she was beaten. I saw that some of the girls resisted, and they started crying when they were forcefully taken away.
This is our chance, isn't it, Steph, to actually hear some of the actual material of what was actually said in the court.
As a result of the forced sexual intercourse that the abducted women and girls endured within the coercive environment of the LRA, at least hundreds of women and girls became pregnant, having no choice as to whether, when, or with whom to have a child. The expectation of women to produce children was central to Kony's motive, which was to create a new Acholi tribe. And this was implemented through the abduction, enslavement, and forced marriage of women.
Yeah, and now we also have a last bit of Sanu talking more about how pregnant women and girls weren't free to leave and were kept.
Pregnant women and girls were not free to leave the LRA. The LRA subjected them to the same coercive and violent environment, including forced exclusive sexual relationships and sexual abuse. The LRA unlawfully confined these women and girls during their pregnancies with the intent to carry out grave violations of international law, including continued enslavement, rape, torture, and the inhumane act of forced marriage. This included at least one of the victims' children fathered by Kony, who was born in Uganda during the charge period, while other children of Kony were conceived and born outside of the charge period and outside of Uganda. These witnesses confirmed the existence of a pattern of forced pregnancy with which Mr. Kony is charged.
No, it wasn't the last. I picked one extra piece. Here's about the abducted women and how they were kind of beaten into submission in this.
Abducted women and girls were subjected to a coercive and violent environment, including various forms of physical and psychological violence, often for a protracted period of time. Many were severely beaten and threatened with violence for resisting sexual intercourse, other sexual violence, or for merely breaking LRA rules. In the words of witness P236, if there is anything wrong, you are beaten. If you do anything wrong, you are beaten.
Whew. So, Lucy, do you think the whole of that kind of substance, the real focus on what happened to women and children, did you find it really convincing?
Yeah. I mean, it was overwhelming almost in every sense of the word, because there was just so much detail also from the victims' representatives today about the amount that individual victims but also groups of victims as a whole suffered, not just throughout the charge period but across the lifespan of the LRA's violence. That I think, to me, it has been very easy in the run-up to these hearings to kind of forget about a lot of that substance in a lot more of these more legal debates about the relevance of this hearing. So I think for me, those presentations were very, very impactful.
I think also I noticed that I sat through the Ongwen trial, and so I've heard a lot of this testimony or related testimony before, and I kind of know what the kind of testimony is about the LRA, but to hear it laid out like this, I have a colleague here who hasn't sat through these trials, who was just sitting in the press room going, oh, Jesus. They're talking about 10-year-old, 12-year-old girls being abducted, being forced to have sex with fighters, being beaten if they're trying to escape. These are mild details of some of the horrors they tell. And I think we often forget, or we focus on the bigger picture or the legal things, and we forget those horrific details. So I thought it was good how they were laid out in this bit again.
Yeah, for me, if we're talking about a concentrated, edited, quote-unquote highlights, then this is it. to understand this substance and to have it just, because usually it would take weeks to go through this kind of testimony in court. And here we have bang, 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 bang all the way through. But we're going to have to move on and turn to the defence arguments. Now, they've kept all of their stuff quite short. So, again, we're not going to go into a huge amount of detail. But my God, there were some really fascinating arguments there, weren't there? Where should we kick off with yesterday, Steph?
Well, yesterday we started with two Ugandan members of the defense team, Jeffrey Boris Anyuru, who grew up during the conflict and really made the argument, what is the point of having this hearing? The people in Gulu want, and northern Uganda want reparations for what they've suffered, and this process will not provide anything. And that is also the kind of comment that we got back as, my colleagues went and asked former Kony victims and child soldiers, asking them, what do you think? And they're like, oh, great that this case is being taken up, but why are we spending all this money for something in The Hague when we are not getting reparations, for example?
And then there's this issue of what's going on the ground, which is transitional justice. There is a process. I mean, it is incredibly long. It's taken forever to get there. But there is an acknowledgement within the capital, within Kampala, that there needs to be something more for the people of northern Uganda. There is the idea that reparations should come in locally at some point. And there's real confusion in northern Uganda about how on earth these hearings fit in with that bigger process. And here's another member of the Kony defence team, Lillian Atim.
We have met political leaders, cultural and religious leaders, victim groups, NGOs, judges, lawyers, returnees, and many ordinary people. We've collected their views on the state of the nation, how best to expedite these historical events, their opinions on the ICC, and this process. Unfortunately, Your Honours, the words self-interested and experiment were repeatedly used to describe these proceedings. Ugandans find it hard to understand how these particular in absentia confirmation proceedings serve the interests of their country.
Lucy, what did you make of the Ugandan representatives in the Kony defence team and their arguments about what's going on the ground?
Well, I think for me, Lillian Atim's argument or discussion there at the end about these ideas of self-interested and experiment really epitomized for me some of the issues with not just this hearing, but some of the ICC hearings more generally, which is who is the actual audience for these things? What expectations do we have when we say the word justice versus the Office of the Prosecutor, versus defence, versus victims in Uganda, versus former perpetrators in Uganda? And the defence really opened up that argument again, I thought, yesterday.
And to, I must say, my delight, we had Peter Haynes leading the defence team because he's always very succinct and clear. And it's lovely as a journalist to have a lawyer that you can get nice and snappy quotes from. And he definitely did not disappoint on that case. We have a bit here from him questioning, what his role should be in these proceedings, given that they've not been held in this way before.
Running alongside what might be termed normal case preparation has been the nagging uncertainty of what our professional responsibilities are in this unprecedented situation for counsel and a defence legal team. For all of us, this is a novel situation. The same soul-searching questions dogged our every decision along the way. Namely, what exactly can a defence lawyer argue without instructions? And what is in Joseph Kony's best interests? Can we assume that he would even wish to contest the confirmation of charges against him? Might he not prefer to waive any challenge and keep his powder dry for trial, or even to plead guilty? How would we be serving his interests by advancing even the most obviously meritorious arguments as to the form of the charges, when one, indeed probably the most likely outcome of any such challenge, would be an adjournment to permit the prosecution to amend accordingly, thereby tightening and strengthening the case against him? How would it be in his interests to point to fundamental flaws in the prosecution's linkage evidence if that would only serve as a tutorial for its investigators, again prejudicing his position for any possible rerun of this confirmation of charges or at trial? How can we challenge evidence without instructions as to his likely plea or his comments as to whether he accepted or challenged the evidence in the first place? And then again, there is the ancillary point of how such an approach would be strategically consistent with the stance we have previously taken as to these proceedings, and our concurrent reluctance to appear to provide a template or precedent for how such proceedings might be conducted in the future. Thus, in due course, you may find our submissions will be limited to issues of process and remedy, which we are comfortable fall within our professional and ethical mandate and cause no prejudice, real or potential, to the absent Joseph Kony.
And then today, speaking on Wednesday, the defence was discussing more fully the actual charges. And Peter Haynes said at this point that, he kicked off by saying he didn't think the judges should actually make any decision on confirmation of charges. And he had some really interesting arguments around that. He basically said, everything's been solved, in inverted commas, by holding the hearings. There's been more publicity on this. Everyone's been informed on what the charges are. Why on earth should the judges actually make any decision in the end? But then he spent a whole load of time really pouring scorn on the details of the OTP presentation. I'm sure had their hackles rising on the other side of the room. But he didn't actually spend any time doing the detailed work, pointing out exactly where they were, where he considered their presentation didn't hold together. Maybe there was one reference to they were talking about thousands of victims, but they only had a list of 200. But in general, he just enjoyed lambasting them.
It was delightfully passive-aggressive. I could complain about X, Y, and Z and then give it little details of X, Y, and Z, but I won't. And you could see the prosecution kind of look slightly miffed at this.
My role is to ensure that Joseph Kony and any counsel that he may subsequently retain to represent him holds the greatest possible latitude to make arguments in relation to the prosecution's case. So you will not be hearing today about the ways in which some of the charges in the amended document containing the charges are legally incoherent or incompatible. You will not be hearing about this serious unreliability of some of the prosecution's central evidence. You will not be hearing about other ways in which the facts have been characterized by the prosecution in a legally erroneous manner. And let me say on this point, there is no shortage of issues in this case that a duly instructed counsel would love to challenge. As a lawyer of over 35 years' experience, I have to say it was painful for me to sit back and not object when I heard the prosecution use such imprecise language as you heard yesterday, referring to at least thousands of victims, and then citing to a list of 204 victims in support of that proposition. Such imprecision would not be accepted in any charging document in any legal system in the world. And lastly, it was very uncomfortable for me to have to sit on my hands as the prosecution presented on screen entries from logbooks as though they were the diaries of Joseph Kony itself. Madam President, Your Honours will know from your scrutiny of the evidence in this case that these logbooks are purportedly English summaries of rough notes compiled by another person who listened into conversations in Acholi in coded language that they oftentimes didn't understand. These logbooks went through many, many links in the chain of custody. But I cannot go into any of that. That's just my personal irritation. Because simply put, in our assessment, it is not in Joseph Kony's interests to give the prosecution the opportunity to remedy the defects in its case while it still can, and attempt to make its case stronger for trial.
Lucy, what jumps out of this defense case that he's trying to make that we really shouldn't have this confirmation of charges hearing? He's kind of fighting a battle from a bad position because these judges have already decided that they should have these hearings. So now his argument seems to be that they can have the hearing, they just shouldn't have a decision. How susceptible do you think they will be to this?
Well, it was funny because I think it was quite a compelling argument because yesterday he spoke a lot about how they had opposed these hearings. And that is a difficult argument to make when you're making it to the people who've already disagreed with you about that, which are these pretrial chamber judges. Today, I thought it was interesting because he kind of said that the hearing has achieved what the prosecution ostensibly wanted it to achieve, although he did, again, slightly passive-aggressively note that, quote, reasonable minds may differ as to whether it was achievable at all. But the question that wasn't addressed in his argument was, and I don't think he was in a position to address it without potentially irritating the judges, was, if they have held this hearing and then don't issue a decision, why, from a judicial perspective, did they hold this hearing? Because, of course, there's all of these very expressive goals of airing things, but does that have to be done in such a legal way? Or can those kinds of tasks be better taken on by civil society organizations, NGOs? You know, so there's kind of then this, if we had the hearing and don't have the decision, are we back at square one with what is the point? And that was kind of the unspoken tension, I thought, in his argument. But I think that has to be left to the judges in the end.
Okay, I'm just going to ask us if we can help wrap up the podcast by pulling out sort of a bit more helicopter stuff and reintroduce Michael Scharf again as a commentator. So the first issue here is the ICC actually turning to doing an in absentia trial. We know it's completely not what's happened at the ICC before, but it has happened in other cases. Here's his view.
Well, if you're from the United Kingdom or another country that's originally part of the Commonwealth, so that would include the United States, Canada, Australia, and many others, there are no in absentia trials. And so this is a weird kind of concept. But if you're from a civil law country or a Sharia country or many other countries, which is the majority of countries in the world, they do in absentia trials all the time. And one thing that you should keep your eye on is the Ukraine cases against Russia that are going to be in the news in the coming months are all going to be in absentia. And the new International Tribunal for the Crime of Aggression of Russia's aggression against Ukraine has in absentia trials. So the in absentia trial thing from an American point of view looks weird, but from the rest of the world, they're quite used to it, and it has been used. Nuremberg, the first ever international tribunal, also had in absentia trials, and there were convicted people at Nuremberg who they were able to get custody over and bring into the courtroom. The problem, though, with in absentia trials is that the defendant cannot talk to their lawyer. The lawyers don't even know where the defendants are. So they can't instruct them. They can't tell them, well, this is my alibi. This is where I was. They can't say, hey, that person has a grudge against me. They're lying. They can't give them all of that really good information that a defendant does when they're working hand in glove with their lawyer. And that makes the lawyers feel like in absentia trials are unfair to their clients.
You've just been through a day and a half, okay, Lucy, so far that we're talking to you of in absentia. Did it make much sense to you?
I think what I'm quite surprised at is that it made sense in some ways, but at the same time, the whole purpose of this seemed to be to answer so many questions we have about Kony's role in the LRA, about the violence that Uganda has suffered, and about what the ICC can do about it. And somehow, I feel like I personally, as an observer, but also someone who has thought about this quite a lot already, has somehow ended up with more questions than answers at the end of it about what is possible for an international court like the ICC in situations of violence like this.
I think we also have to look a bit at the big elephant in the room, really, which is Kony is interesting, but what happens after Kony? Why do you do this? And Scharf thinks that Sudan and Libya are the next two situations that might see also these kind of hearings in absentia, and maybe even climbing up to other suspects on the lam.
It may be that they are teeing themselves up for future cases. And I would think that the first to be used with this proceeding would be the Saif Gaddafi case. That's the son of Muammar Gaddafi, the former ruler of Libya. He's been indicted and the Libyan authorities have let him go and nobody's sure where he is. And now that's been over a decade. So that's getting close to the Kony situation. Then you've got al-Bashir from the Sudan. You know, he was indicted for genocide. For a while, he was running the country. Then they took him into custody. Then they said they would surrender him to The Hague. No one's quite sure where he is either. And so both of those are very similar to the Kony case because the standard is that the individual has to be someone who cannot be found. Now, when we're talking about Putin or Netanyahu, we know where they are, right? They're sitting in their office in the Kremlin or in Tel Aviv or Jerusalem. It's clear where they are, but depending on how you define not to be found, it could be that this process could be used against them because even though we know where they are outside the reach of the ICC. So it's possible that over a period of years, and you know those indictments are still really fresh. In the case of Kony, they said, well, you know, we waited 17 years, now we're ready to try this. And like I said, the other cases of al-Bashir and Gaddafi are very old too. In the case of Netanyahu and Putin, we're talking about just a couple of years. So they're not going to do that anytime soon. But if the International Criminal Court finds itself, you know, increasingly frustrated with its inability to bring them to justice, and the crimes that they're committing linger on and continue over year after year after year, I could definitely see them trying this procedure. And therefore, the Kony confirmation in absentia is a trial run and an important precedent for these other bigger cases.
So, Lucy, I could see your hand gestures as you were listening to us. I'm saying Scharf rather than Scharf there, but I mean, I'm gonna stick with the Dutch pronunciation.
No, I think it's Scharf, no?
I'm sure you're right, but apologies to Michael. I'm sure I've got it wrong, whichever way round. What do you think? Are we going to see more of this, Lucy?
I don't know. I think the argument by Haynes really sets it up that the issuance or non-issuance of a decision, even if, for example, the judges were only to confirm 10 charges, but the act of issuing the decision will set a real precedent. And I think if they do issue a decision, we could see more of it. But there's a real risk, I think, of reproducing some of the biases that the court has been accused of in the first place, because, you know, as we heard in that excerpt, this is much less likely to happen for leaders like Putin or Netanyahu, of course, for quite technical reasons, because they can be found in a way Kony couldn't.
But they also look like the kind of leaders who have protection.
Yes, and because they have protection, I'm not convinced, or I cannot imagine any circumstance in which, even if Putin went on the run tomorrow, that there would eventually be an in absentia hearing for him. And so there is a real risk, I think, of reproducing the alleged neo-colonial bias that the court was accused of so often in the early days of Luis Moreno Ocampo's reign as prosecutor.
I was thinking sort of in terms of some of the final bits and pieces. I was wondering, let's say Kony or any other person for whom this kind of procedure is introduced, let's say they get arrested. What on earth happens then? Who puts them on trial? I mean, in Kony's case, Uganda could, as Peter Haynes said, is not Uganda fit and willing? It's just done a trial with Thomas Coelho, which is now in the appeals stage. Surely Uganda would put him on trial. Why would they hand him over to the ICC? If he was handed over to the ICC, wouldn't we end up with another confirmation of charges? What do you think, Steph?
Yeah, that's one of the arguments Haynes was making, that in the Special Tribunal for Lebanon, which had these in absentia cases, that he said that the judges there decided that if suspects would finally show up, they would have to redo the entire proceeding. So, yes, confirmation of charges hearing. So I think he was also making that point of the kind of waste of money and resources in this. It's something that will need to be hashed out. And I think that's why the ICC went with a kind of a baddie that most people want to see on trial, to kind of see and test the waters of how this procedure would work before they try it out in other cases. But yeah, as Lucy said, those circumstances are very different. And we've also found that these very specific different circumstances sometimes also lead the court to make exceptions in other cases, all based on, the precedent they have, but they're all slightly different. And so you can always make the argument that because legally it is slightly different, that they don't have to make the same decision as they did in other cases. And I think that's something that whatever they decide in this case, future cases might also look at and be different than what's decided here. But of course, we've never seen it before, so this is the only thing we have to go on.
So, Lucy, final thoughts before you hair off? We're delaying you from going back to the final session.
My final thoughts is that I think this was a real lesson for a lot of observers about what expectations we also have of international justice and international justice hearings. And it also, for me, the biggest takeaway from this is that the question of audience is the most important. Who are any ICC hearings for? Not just judgments, but actual daily hearings and airings of evidence, even if it only takes 30 minutes. Who is it actually being done for? And whatever your answer to that question will kind of dictate your stance on proceedings like this. And I think that's been the real takeaway for me from these last 2 days.
Thanks so much, Lucy, for giving up your time. Lucy's Substack is called?
I don't know. Lucy Gaynor is my Substack name, so that's what I write it under, and it's usually just my observations when I observe trials. Maybe I have a catchy name that I've forgotten, but I don't think I do.
We must come up with a catchy, punny international law name. We'll think about it. But I think Lucy Gaynor at Substack, if you want to follow it. I like to have the last word, but I don't have any more sensible observations than the very great observation that Lucy made, so I'm going to shut up.
Nevertheless, Steph, you've almost got the last word.
As I should.
This was Asymmetrical Haircuts, your international justice podcast, created and presented by Janet Anderson and Stephanie van den Berg. This episode was created in partnership with Justice, an independent site covering justice efforts for mass violence, and with the Hague Humanity Hub. Music is by Autonautics.com. You can find show notes and everything about the podcast on Asymmetrical. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.